present you today part of my work. It's a great pleasure to be here and hear all the lectures that are coming today, as they also are part of interest in my PhD. So really thank you to the organizers for giving me that chance. As Stephen mentioned, I'm in my third year of my PhD. The deadline for my submission is August, so that's also the reason that unfortunately today is the only day that I can stay. Work is in a progress and it needs to be done. Today I would like to present you part of my PhD, which is one of the chapters. The general thesis is regarding the specific problems that public sector directive poses when we are considering establishing public-private partnerships and also its promotion and operation. The approach that I took in this project was to look kind of chronologically through different stages of establishing of PPPs and what problems would arise on the go. And first of such a problem is arising just at the beginning when we're dealing with the project and we want to classify it as specific public contract in the framework of public procurement regulations. The element that I will be talking today about is institutionalized public-private partnerships, so a form of the most complex contract would include many different aspects. So it will include not only the work aspects but also service and supplies, and on top of that it can also involve developing of certain innovation or, for example, bringing to life an institutionalized framework such as joint venture. What happens in the cases of institutionalized public-private partnerships. Why it is important to appropriately classify this type of projects? Because obviously it will dictate if the public procurement directive will find its application or the project will fall outside of the directive. Furthermore, we wouldn't need to apply this law. The main part of my research was or is in that aspect focused on two case law, which is Hotelu-Traki and Olun-Kapunki case. And furthermore, I will go briefly through the facts from this case. And afterwards, I would present a couple of critical remarks that I managed to identify during my research. But first and foremost, to start very briefly, I would like to present you what the theory of the mixed contract is and what I mean by saying institutional public-private partnership. When we're talking about the mixed contract, the directive gives us a helpful hand when we're dealing with contracts that involve more than one form of public contract, so supply, service, or work. Is the institution of mixed contracts, which states that when we're dealing with contracts like this, we need to find a solution to classify it under one set of regulations. As such a project cannot be regulated both by rules for specific service and at the same time for works. It needs to be decided one on another. And in this point, the institution of mixed contracts comes in, and we're dealing with two different approaches that we can look at. First one is the main purpose of a contract. So when we're dealing with such an IPPP, we're looking what is the main focus of the project. What is the main aim that we would like to gain through that project? And second is the value of individual element. That one is specifically focused when we're talking about different type of services, but as a helpful hand, it also is used in broader sense. However, those two approaches are mainly focused on the contracts which include just the different forms of public contracts. They not deliberately state that those are also applicable to contracts that, for example, establish a joint venture or includes innovation. Furthermore, the question that I was trying to answer and the element that I was trying to research was if those rules are applicable also to wider understanding of institutional public-private partnerships. As I mentioned, those partnerships are the complex form of contracts that involves establishing of a joint venture. Establishing of IPPP is not per se regulated by the directive. Furthermore, it is still questionable if such a partnership needs to be established in a legal framework of directive. However, when we would look into communication from European Union, it is stated, never mind how the institutionalized public-private partnership is established, it still needs to respect the rules of European Union treaties and rules of European procurement directives if they involve public contracts in them. And that can be done through two different ways. First of all, such a partnerships can be established with preferred private party, and then as such a semi-public company, they can participate in public awarding and compete for award of a contract, or it can be done in a single procedure, which is much more preferable. When in one procedure we're choosing a partner for our partnership, and at the same time we're awarding the contract. When it comes to those two cases that I had a look on, they both are concerning institutionalized public-private partnerships. First one is a case of Hollutraki, which was a case in which public authorities published a public notice informing that they would want to procure a mixed contract which will involve 4 elements: the transfer of a block of shares of a public casino, furthermore a form of partial privatization, entrusting the management of such a casino to private partner, and executing a development plan which consists of casino premises and improvement of surrounding areas. So just from description of this contract, we can see that they're involving works and they involve services, but at the same time it's an element which is not covered by procurement regulations, which is a sale of shares of a public company. In this case, court came to a conclusion that this is indivisible contract which needs to be treated as a one whole, and the main purpose of that contract was the sale of those shares. Furthermore, all contract follows the main purpose of this project and falls outside of public procurement directives. Furthermore, in the conclusion, court established that this specific contract didn't need to go through public procurement tender procedure. Surprisingly, next case, Olunkapunki case, which is regarding to some extent similar factual circumstances, as up here also was established a form of semi-public company, which was a joint venture between Finnish public authority and private partner, with the aim to supply the provision of occupational health care and welfare service to private entities. What was differing this case from the one before was that in this case no public notice was published. It was done in a way that we could describe behind closed doors. Furthermore, partner was chosen and they decided that they will establish a joint venture together, and this purpose will be fulfilled. The additional notice to the additional element to the contract was stating a transitional period of time of 4 years. And during that 4 years, public authority would purchase the same service for their own staff members. Furthermore, that service automatically became a form of public contract. The question was, is such a scenario ruled and governed by the directive or it's not? In this case, obviously, court came to a conclusion that Finnish public authorities violated procurement rules, and there was no open competition stated in the form of tender. And furthermore, the violation of rules dictates that such a contract should be established with mixed contract. With the public procurement framework. There are a couple of elements that obviously state straightforward what are the differences between those two cases, but at the same time there are several that definitely makes them similar. From one perspective, we could say in a case of Olunkapunki, the main purpose in this case was provision of private services to private parties. Furthermore, as such, it shouldn't be covered by the directive, and the same in the case of Hotel Lutraki. But the part that court focused in the second case was not the main purpose as much as deciding if such a contract is divisible. So the conclusion came, and the problem that I've noticed is that at this point we're not dealing anymore with what is the main purpose of the contract, but we also need to have in mind if such a contract in eyes of a court can be divisible, separable. So the aspect of public contract will be still covered and put out to tender. Also, when it comes to approach towards those two cases, court took very different perspective. When in Hotel Lutraki, the approach can be described as much more lenient. And what I mean by more lenient is that the court based its judgment on qualification, legal qualification that was done by the national court. So national court decided that this contract was a mixed indivisible contract, and CJU took that as granted. When in the second case, what the Court of Justice stated was that we will conclude our own qualification of the contract. Furthermore, we will decide if this contract is indivisible or the parts of it should be put out to a tender. There were different elements that were established as the reasons why the two rulings were decided differently. And some of them I've looked through and tried to establish what exactly we as public authority or we as a private party interested in being part of PPP or being part of IPPP need to focus on if we want to make sure that our contract will be looked at as indivisible and wouldn't be later on separated into separate lots. And when it comes to evidence on such an indivisibility of a contract, in Hotel Lutraki, element that was mentioned was a contract notice. And such a contract notice was described as, because the contract notice characterized a contract as a mixed and indivisible, that was a part of evidence, a part of a proof of such an indivisibility. However, the element that I would like to point out is the fact that contract notice is a very short information, or very vague description of the contract per se, especially in the context of such a complex contracts. It's more of a form of a statement what public authority wants to conduct than form of evidence of indivisibility of a contract. When it comes to a Finnish case of Olunkapunki, such a contract notice was not published at all. Furthermore, up here, that's evidence that was not provided in any way. However, the linkage between the institutionalized form and establishing of a company and the public contract was a form of capital contribution. And that element was very important for the public authority to underline during the proceedings, stating that the capital contribution of the form of transitional period of time during which public authority will purchase the service from the IPPP was its capital contribution to this form, and at the same time the main reason why such a institutionalized public-private partnership was established in the first place. Unfortunately, court didn't see that as sufficient evidence, pointing out that that's more of a statement of intentions than objective evidence in this case. Another element that was underlining the indivisibility of a contract in Hotel Lutraki case was the argument that the contract was conducted with a single partner, and as such that underlined the wholesome of the contract as one. The element up here that I would like to point your attention to is also the understanding, how we understand a single partner. Isn't that also a form of technical procurement descriptive element, in the sense that we're dealing also with consortia. Furthermore, what could understand in this specific case by single partner can be also debatable, because obviously it can mean different things. However, there was no much more stated in that regards in the case. Interesting part is also that exactly the same scenario happened in the case of Oulun Kapunki. The contract was also conducted with a single partner. Furthermore, they needed to go through the same process of being able to technically and financially prove themselves as sufficient and effective partners to such an endeavor. Element of divisibility of Finnish case contract was the element of the ability to establish or ability to survive without the certain element of a contract. And that was stated by the fact that in Finnish court, one of the competitors of the private party brought up a proceeding stating that the contract was invalid due to not opening the competition. Furthermore, that element should not be transferred to IPPP. And that's what happened. All the activities on municipality were transferred to IPPP. However, the element of provision of a service for the public authority was not. And that was also an element that, in eyes of a court, was a proof of a severable nature of this specific contract. What I would like to argue is the ability to survive without certain element should be the approach that we should take on. Because obviously, I'm of a belief that majority of PPP's contracts or IPPP's contract objectively could be divided. So the establishing of company could happen by its own, and provision of service and provision of work could happen on its own. However, the aim of conducting such a contract is different. There are certain benefits of concluding a contract in a form of PPP, and that's also a reason why conducting all the aspects in one specific contract are established. Furthermore, efficiency of such a contract is at risk to some extent, and I think that more the test of ability to deliver at the same terms and conditions contract without that specific element or in its separation should be taken into consideration. What is also very interesting is that in the Finnish case, the fact is that the main purpose of the contract never was established. The court only discussed the elements and focused on the fact how we can divide that contract into parts. But it never focused, like it did in Hotel Loutraki case, the main purpose of it. And if it would focus only on the main purpose, I'm of a belief that it would come with the conclusion that the situation was quite similar to the one in Hotel Loutraki, as the main purpose of conducting IPPP in Finland was the fact of provision of the service to private parties. And only provision of those services to public authority was of a 4 years, so of a transitional period of time. And also the public authority provided evidence stating that the economic value of provision of those public contracts to public authorities was of a much less value than what is the economic value of the service provided to private entities. Furthermore, to some extent, it is not understandable why those two cases have such a different approach. Obviously, it can be seen because the Finnish case was the second case chronologically to the Hotel Loutraki. We can try to understand the approach of a court in a way the court understands it if we only apply the method and the theory of the main purpose of the contract. There will be a valid amount of contracts that will still fall outside of the procurement directive from a simple reasons that public authority will include other aspects to a contract, such as sale of the shares. Furthermore, they came to a conclusion that additional help in interpretation of those rules is needed in a form of assessing if the contract can be divisible in any of the parts. There's a couple of more aspects in those two judgments that I took into consideration, but obviously due to the limited time, I'm not having a chance to discuss all of them. However, I hope that at least these points make you interested, and maybe some of you would like to read the paper, which will be published. So I think that will be it. I welcome any comments and any questions, and thank you very much.